This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
There we go. Welcome, everybody, within distance of my voice, which is so loud that it's probably everybody on the planet. This is Ask a Lawyer for Friday, August 2nd. Please feel free to give me a call with legal questions or maybe even some jokes. It's 340-1590. That's 340-1590. I'm going to begin today with just a couple of really short stories, given the day it is. It's August 2nd. August 2nd, my father's birthday. He passed away in 2010. And so, obviously, this time of the year, there are a lot of thoughts. I did a nice Facebook post. But I will tell you, I remember when I came home sometime during my sophomore year of high school, I had just begun engaging in speech and debate. My grades had not yet changed from C's and D's. And I told them I was going to become a lawyer. My father laughed. It was not within the realm of reality. But I do recall that at my law school graduation, he remembered that particular incident and told me he was wrong. So, no, people did not think I'd be a lawyer in high school.
Yeah, well, it shows you how you can turn it around.
That's right. You can turn it around.
You bet. Yeah.
The other little story is August 2nd is also an interesting date. It's the date almost a quarter century ago where my grandmother from Montreal passed away. Now, she passed away on my father's birthday. There is speculation within the family, led by my mother, that my grandmother did this on purpose. Because
Wait a minute. What?
Well, this is because when my father met my mother in the Canadian equivalent of the Catskills, and then they started dating and everything and then couldn't get married, it's obviously taking her out of the country, from Canada to the United States. And back then, the only mechanisms of communication were handwritten letters and telephone.
Sure.
Telephone was very, very expensive to call another country.
Oh, yeah.
In
back
1950s.
then. Yeah, back then, you bet.
So my grandmother did not see or hear from my mother as often as she would like. And my mother said, facetiously, of course, that she had a feeling that maybe my grandmother waited just an extra day to screw up my father's birthday.
Spite.
What can I tell you? The other quick little story is I had a great relationship with my grandmother from Montreal, and she's a wonderful lady, and maybe one of the closest relationships I've ever had in my life. But whenever I would visit, she would ply me with candy bars, chocolate bars. And of course, being at that young age, as I grew older, but at that young age, I was not going to say no to a candy bar. I don't know if I'd say no to a candy bar right now. The problem is, every time she would give me a chocolate bar, and I would gobble that chocolate bar, she'd then say to me, "You're so fat! Why are you so fat?" Now, I wasn't astute enough back then to say, "Well, Bubby, you just gave me a candy bar." But I always found that a little amusing as I grew older, that the candy bar was followed by some good old Jewish guilt.
Yeah. Yes.
I also hear that Italians have good guilt. And
Oh, yeah.
There are other nationalities that we don't have the market on guilt.
My mother was 90 pounds soaking wet, and she used to always nail me on my weight. Oh, yeah. Yep. Oh, yeah.
What can I tell you?
Yep.
All right, so what are we going to do today? Today I thought we would talk a little bit about parenting modification plans. We spoke a good while ago about family law, divorce, child support, these types of things. But I thought we'd talk a little bit more about parenting modification, and if we have time, a little bit more sort of a reprimer on defamation.
What is parenting modification?
All right, you have a divorce, you have a kid. Part of the judgment of divorce is a parenting plan.
Okay, well, that makes sense. Yeah.
Okay. Now, very
like
often,
shared custody,
right?
you're saying. Okay.
Very often down the road, circumstances arise where one former spouse or the other feels a need to have it modified. In order to get a parenting plan modified, you either are going to have agreement and you're going to prepare a modified parenting plan, and either with or without attorneys, you're going to submit it as an agreed upon proposed parenting plan with a proposed order for the judge. And almost routinely, if it's agreed upon, the judge is just going to sign it without really looking at it very, very carefully. You have a lot of work to do there. But more often than not, you don't agree on the proposed modification. So what do you do then? Well, the only mechanism to change a parenting plan is a petition for modification. You file a petition with the court. Let's say you got divorced here in St. Lucie County. You file a petition with the clerk in St. Lucie County for modification. And then you file all the required paperwork, which is a lot. And eventually you get a hearing. And
how eventually is eventually?
And you get a mini trial. Well, we talked about that a while ago. Eventually in family court, unless it's a matter of serious health or safety of the child, a year or so. But whatever you want, let's say it's modified child support, it's retroactive to the date you filed the petition. So you shouldn't wait to file a petition if you really need something.
Yeah, but usually you and your ex can work out.
Well, that's the goal. That's something we're going to talk about right now. The goal is to try to resolve these things without court intervention, because court intervention is expensive, it's time-consuming, and quite aggravating. But what do you do if your former spouse is a narcissist? What do you do if your former spouse is passive-aggressive? What do you do if your former spouse engages in projection? In other words, blaming you for their own faults. In other words, they cheated on you, so they blame you for cheating on them.
Okay, I got
They
you.
project.
I was going to say, what do you do? Well, okay, yeah, now I get it.
And what do you do if your former spouse engages in imaginative reality revision? I'm sure there's a psychological term for that, but...
Yeah, it's called politicians.
Well, that's true, too. All right, so what do? The first thing is it's a practice tip. Before you run into court, there is a piece of software which I knew nothing about until I got involved in my own proceedings in 2012, called Our Family Wizard.
It's a computer program.
You get it on the iTunes Store, you get it on Google Play.
Okay.
It's an app. It's called Our Family Wizard. You can also look it up at ourfamilywizard.com, and I don't get paid anything by them, trust me. It's just that I think the program is phenomenal. What it is a program where both spouses can email each other. Well, that doesn't sound so exciting, but wait, there's more. You can also put down the parenting plan so the calendar shows I have Billy this time, you have Billy that time. And then you can do trade requests. Now that sort of sounds like sports.
I was going to say,
and
who's the player
I don't
later?
think I don't think it's a great word to use, but a trade request is, well, you have Billy on Saturday according to the parenting plan. I'd like to have him Saturday. I'm going to offer you next Wednesday instead. That can be accepted, rejected, or countered. but there is a record of it all. So if you make 20 requests for trade requests, and they're all reasonable, you give the reasons, they're all rational, and every single one is rejected or ignored. Well, if you end up having to go into court, everything on our Family Wizard can be pulled up by the judge on their laptop because the judge has unlimited access to the program.
Okay. Wow.
That is one of the good things about it.
I was just going to say, why don't you do this verbally? But here is a printed record.
So when you email each other, if it ever comes to pass, it's right there for the judge to pull up on their computer. And the goal then is obviously to get you communicating to each other civilly. In fact, if you want to pay, and it's only $99 a year, it's not very expensive. If you want to pay, I think it's another $20, you get what's called a tone meter. So when you draft your OFW message, your email to your ex-spouse,
Yes.
it comes up in red and blue and green and tells you argumentative, passive-aggressive. So it suggests that you may want to revise certain portions of your email. I did that for the first year, and I got to admit it was really very valuable. After the first year, I figured I could just do this myself. But not everybody can. So, it's helpful to try to make sure you stay civil. And I've spoken to a lot of people who have no knowledge of this program, but I will swear by it personally. I still use it 7 years later. For a year or so recently, we did not use it because we were communicating perfectly. Phone, text, everything. Then something happened, and we're no longer communicating so perfectly. So we're back to our Family Wizard. And this way, one of us wants to be outrageous. Well, it's going to be there easily for a court to see. So, before you start running into court, I would really suggest that if you have difficulty in communications with your former spouse, or if you have problems with the parenting plan being adhered to, or in needing to change periodically dates for whatever reason, your parents are coming in from Idaho. Oh my goodness, it's my former spouse's week. You do a trade request. Okay. I would recommend strongly that anybody who has a child and is obviously divorced get the software, even if it's not court mandated. Okay, because it will be very helpful, I think, to both spouses. That's a practice tip. It also helps when your former spouse might be narcissistic, passive-aggressive, or engages in creative, imaginative reality modification. Fancy words. In other words, they're not exactly telling the kosher truth.
They're not cool anymore?
No, not really. All right, so let's say you have our Family Wizard, OFW, or even if you don't, and you've got some serious issues, you've been trying to resolve them. They could be with child support. They could be with, I hear this often. I was supposed to get my kid back on Sunday at 6, and he was nowhere to be found, and I didn't get him back until 2 in the morning. Well, fortunately, you got him back. I also hear the stories of, I was supposed to get him back Sunday at 6. We're supposed to meet at this gas station to do the exchange. He never showed up. Or she. I also hear sometimes, I'm supposed to have Johnny back at 6 o'clock on Sunday, and my ex says, I'm not reliable, and he doesn't trust me right now with Johnny, and he's keeping him. Well, these are serious issues. A few practice tip suggestions before you have to go to a lawyer, before you have to try to file a petition for modification or for an order for to show cause while your former spouse shouldn't be held in contempt for violating the existing order. Before you have to do any of that, before you got to spend a lot of money on a lawyer, me or anybody else, trust me, it's going to be a lot of money. When a lawyer hires a lawyer and he's told about the retainer, trust me, even the lawyer turns white. These things are inexpensive, and I think every lawyer probably should need a lawyer at some point, because it brings you back to reality as to what your clients feel.
So you mentioned an exchange at a gas station or something like that. Why wouldn't you not just take them home or pick them up at home?
Well, sometimes they don't want you to come to their house.
Okay, yeah.
Or sometimes maybe the gas station is midway between your house and their house.
Okay.
Or the chocolate shop. If you have a problem getting your child back, before you call the lawyer, before you run into court, my recommendation is that you always carry in your car a copy of the judgment of divorce, really it's called a judgment of dissolution, which includes the parenting plan. Always keep it in your glove compartment or whatever. Comes in handy. For example, doesn't always work, but it often works. I've heard it from other people, and I've recommended it to people. Your ex doesn't show up at that gas station. You can't get them on the phone. They're not responding to texts. It's your time to have your child back. Call the police. Call the police. Show them the court order. Show them that this is now your time. And, take a little trip over to your ex's house. And if they're there, very often the officer will require that child to be turned over because they see an order in your hand. It works very well. Now, I have heard sometimes the response of the police officer is, this is a civil matter, and they won't do anything.
Yeah, I can see that.
Frankly, I think that's hogwash. I think that's a lazy cop, and I'd be filing an internal grievance against him with the department. But that doesn't get you your kid back. Now either you have to let your former spouse, who is maybe engaging in a power play, you get the kid back a day late, whatever. If it happens once, again, don't run to a lawyer. Costs too much. Takes too much time. But if it's happening repeatedly, you have no choice but to probably seek an order to show cause for contempt or a parenting modification. And as we take a break here, before we go further, we have John on line 1. Hi, John. How can I help you? He's doing all right. Thank you. That's right. All right. Tell me what happened. Baloney. Well, maybe they were trying to see something that was really small. I don't know. No recourse for that. No, you don't want to show Exhibit A. You don't want it to be put on the table.
You were talking about guilt on the Jewish side and the Italian side.
Yes.
And many years ago, when I was living in Boston, I had a lady friend in Worcester, which is about 40 miles west, and she had a grandmother. She was 100% Italian. The grandmother was probably 85, and she would lie about her age and say she was only 80,
Yeah.
But she had a relative in the building that kept an eye on her, although she was, healthy and got along pretty well. Well, this day the lady couldn't be available for her, the relative. So the lady I was dating and I said, would you like us to spend the day with you? If you need anything, we're right here for you. And she said, in broken English, No, don't you worry. You go. You have a good time. If I fall and I break my leg, I lay on the floor. The police will break the door down, and they will come and
You do that in an Italian accent. I've heard it in Jewish.
There used to be a radio host named Larry Glick, very famous up on WPZ. I'm sure that Carol Wyatt would remember him. But he used to have a clip, about a lady calling her mother and telling her what a beast her husband is, and
Right.
he's Jewish. And he says dirty things to me, terrible, hateful things. She said, like what? He said, clean, cook,
Right.
Stuff like that.
Right. Tell the wife to clean and cook. Right. That's going to get you a black eye.
Yeah, so anyway, she says, why don't you come and stay with me for a while and get away from him. He's a beast. So she said, well, I don't know what to tell Andrew if I leave. So the mother says, Andrew, who's Andrew?
Yeah.
Isn't this, and she gives her the number. She says, no, you've got the wrong number.
Oh, gosh.
So the lady says, does that mean you don't want me to come?
Oh, gosh, John.
Yeah, the good old days,
That's right.
Well, anyway, good to hear you on the radio. I'll be listening.
Thanks for the call.
Well, did
Take
I
care.
got engaged to
What?
a lady with a wooden leg?
What was that?
Did I tell you I got engaged to a lady with a wooden leg?
Oh, not another
No,
joke.
no.
Not another joke. You only get
Well,
one per call.
Well, I broke it off.
Oh, gosh.
All right. Bye-bye.
All right, bye-bye. Oh, gosh. Well, folks, you don't want to hear those jokes that I just heard on Facebook that
We need a
still
disclaimer for
can't
our
hear
callers.
it. Right, yes. All right, so going back to what we were talking about, if you're having repetitive problems and you want to still try to work them out before the lawyer gets involved, before the court gets involved, well, I guess some suggestions that I've heard about are, if it's possible, the parents having a discussion. That may not work. If you need to, having a discussion through counsel. That does get the lawyer involved, but maybe resolves it before any legal papers have to be filed. Or, if you two are willing, you might have a discussion with your clergy, who might help mediate whatever the issues are in the best interest of the child.
That makes sense.
I can tell you that some clergy that I know, who will remain nameless, the interest is in the child, not you or your former spouse. So it's a good way to go get help, because if the issue is with the kid, which really is the only issue that the court's going to care about, they don't care about the two of you. It may be a way to get an agreement, get a resolution, before you have to run to court. And if all that doesn't work, and you're imaginative, and you have ideas as to how whatever the problem is can be resolved, prepare a peace plan. Write it out. Have a proposed peace plan that can be presented through some neutral party, whether it's the lawyer or the clergy or a good friend or somebody in the family that still talks to both of you. These are alternatives, possible alternatives, before you go full hog with a lawyer and get the court involved.
You say peace plan. It sounds like warfare.
You want to know something? It is warfare.
Wow.
In the best situation, former spouses actually like each other. And it makes working together in the best interest of the child simple, easy, and even sometimes pleasurable. I know a family like that, where once you're in, you're never out. You can be divorced, it doesn't matter. You and your ex-wife and then your second ex-wife will still be at the party with your first ex-wife. And it works very well in that family. I'm not going to mention the family.
Okay.
That's the optimum situation. Most are not the optimum. There are some that are so horrific, communication is barely tolerable, where you really do need a family wizard, I'm telling you. And putting something in writing as to what you expect and what you need and what you're willing to give in return. A peace plan sometimes might get the discussion moving along. And sometimes it doesn't. And at that point, well, you may need to go into court. So we talked about some of these alternatives. What happens if they don't succeed? Well, then I would say ask yourself some questions. Were you at least able to get most of what you sought? You know, a commitment that the kid will be returned on time. In exchange, you'll do X or something, you know, some small concession. Have you been able to get most of what you want? Were you at least able to get the key points of what you want? Again, with the focus on the child. Now, that doesn't mean you're not relevant. For example, if the kid is supposed to be returned at 6 o'clock, so you make arrangements to be home by 6, and the kid's not returned until 11, that creates a serious inconvenience for you as well. And the court is not insensitive to that, because the reality is, in an optimum family where you have two parents and you have a kid, you don't get any time off. The only time off you get, no. The only time off you get is when your spouse is able to carry the load a little bit and maybe let you get out for an evening, you know, something like that. Or the grandparents watch the kid. You know, that's your time off. Other than that, you're stuck for 18 years.
So we told the kids, we'll watch the two.
Yeah.
You guys have a nice dinner.
Now, 50 to 60% of families now, you don't have those two parents. You're living with one parent or one parent different times. Mm-hmm. And so the court recognizes in those situations that when it's the other parent's time for time sharing, you have the right to make plans for yourself. You have the right to recharge your batteries. If your kid's going to your former spouse for a week, you have the right to go on a vacation, not to be called back because of problems. And these issues come up in court where time sharing is cut short all the time because of one issue or another, and that makes it impossible for you to make your own plans, whether it's a vacation or going to the theater or going to the rodeo or whatever. So the court realizes that when it's not your time sharing, you should be free to do the things that you would normally do if you're single, because you are single, and not to have the time sharing interrupted because you have to have an early pickup because of some problem.
You're sort of single.
Well,
you not are single.
You're single with a kid.
Right, yeah.
But you're not married, you're single. You're divorced. All right, so if you don't get the key points, were you at least able to get things that were important to you? And ask yourself, under the circumstances now, can a rough peace at least exist? At least for a period of time. If so, best thing to do is keep working at it. If not, it's time for war.
Holy smokes.
Or as Cliff says, let's get ready to rumble. And he's right on that count.
And you bring Donald Trump in as a
No,
consultant.
gosh, no, don't ever
That
mention,
is war.
Don't mention that name. I mean, I may talk in litigation about nuclear war, but I'm afraid that guy will really start one. All right, so keep in mind one other thing before you go forward. While the primary interest is the best interest of the child, your own emotional interest, sanity, is pretty relevant as well. If it is being so distraught by the interactions you're having with your former spouse with regard to the child, then you got to go forward. You hope it's a short-lived process. You hope that merely filing a petition for modification makes the other side see their version of the savior and come to a resolution, and that you don't end up a year later actually having a mini trial in front of the magistrate. But you got to be prepared for that.
Now, does the child have to be there?
Typically, no.
Good.
Depends upon the age of the child.
Yeah.
There's no hard and fast rule, but typically, if the child is under 13, 14, you two are going to knock it out on your own with whatever witnesses you have, and the child is not going to be a part of it. If it is absolutely critical for whatever reason for the child to testify, that is usually done very, very gently. It is usually done in the judge's chambers, not in the courtroom. Very often, the parents are not even allowed in. It's the judge, the child, the court reporter, usually the lawyers, but sometimes not even the lawyers.
Wow, so it's just the judge and the child.
When it comes with a minor, the judge has a lot of discretion.
Okay.
And if the judge thinks things are so antagonistic, or that one attorney is going to be a little bit too brusque in questioning a young child, the judge might just take the child in alone into chambers with the court reporter, or with somebody the child trusts to be there, and ask some questions.
Now, is that something really unique, or
No,
does that happen a lot?
No, it happens. It happens when it's necessary. If you've got two parents who are in a battle and are civil with each other in the courtroom, then maybe you don't need that. But if you've got two parents, through their attorneys, who are nasty and belligerent, and you don't want the parents, you don't want the kid having to talk to the judge and say something that might hurt one parent. Kids are sensitive to that. And so you may not get the truth. You want the truth out of a kid in that type of a high-stress situation. You let the kid's aunt come in. No parents, no attorneys. You talk to the child at a level that most family judges know how to do. Non-confrontational, soft. You ask all sorts of general questions that are fun before you lead into the important stuff. How's third grade? You have friends? What do you do during recess? And you get a rapport with the kid. And then the judge, asks the really important questions. The child may still hesitate to say something negative against one parent. But you can probe a little bit if you're a good judge and try to figure out the truth. But that's going to be almost impossible if both parents are sitting in the room. Okay, and if a situation is so serious that you need to have a young child testify, that's probably the best way to do it. Now, when you get to 13, 14, 15, and above, the court will very much take into account the child's preferences. So let's say the parenting plan is week on, week off with each parent. And let's say the kid's now 15 and doesn't want to do this anymore. It's too much of a hassle to have two households. When I go to this household, I can't spend the weekend with these friends. Or, this parent won't take me to the school dances, so I really would rather stay with the other parent who will do this for me. Those, some reasons a kid are going to give are going to be frivolous. Some of them are going to be serious. If a kid has a legitimate reason that says, no, I never want to see the other parent again, but I'd like to change things too, so that I make sure that I can go to my baseball games. The judge is going to probably take that into account. If the child who's of that mid to late teen age comes in either in open court or even sometimes in chambers, but more often in open court now, says, I have a problem with one parent. I'm not getting along with that parent, and here's all the reasons that I perceive it to be. And then, of course, you're going to have other testimony when the kid's not around. And, the judge perceives that the kid has some merit in what he or she is saying. For whatever reason now, at 15, they're having difficulty with one parent. They can really only open up to the other parent. I mean, look, the reasons could be thousands. But let's just say it's a girl, beginning to have, that's a little old, but beginning to have her period, not comfortable talking to dad, would now want to spend a little bit more time with mom.
Which makes sense.
Makes sense.
Yeah.
Now, hopefully the two parents could resolve that on their own, because it makes so much sense.
I would hope so.
But if you can't, and you're in court, and the judge hears that, I think it's pretty certain that the judge is going to arrange for more time with mom, because teenage life is stressful enough. So there are all sorts of reasons why this might come up. It could be parent-generated, it could be child-generated. And if the child is trying to generate this and parents aren't listening, I know most children don't realize this, but hopefully there's an adult that's close to them that does. They could petition for a guardian ad litem who goes into court and argues what's in their best interests. Represents the kid, not the parents.
Okay, what if the child exaggerates a lot?
Well, that happens a lot, right? I would hope that if it's a younger child, a judge is going to be able to ferret it out. If it's an older child, they're going to be subject to cross-examination. And hopefully you have a good enough attorney that can give the instances, examples, as I call the ammunition you've given your attorney, to not beat the child up, but to show that the child is an exaggerator. So that maybe that testimony is taken less into account. But the reality is, you may have to go to court. So, what's the reality of going to court, at least in our area? We are in the 19th Judicial Circuit. That's Okeechobee, Indian River, Martin, and St. Lucie counties. With maybe one or two exceptions in each of these counties, you have one family court judge and a magistrate. Maybe two family court judges.
For 500,000 people?
Well, in each county.
Oh, okay. Gotcha.
And that's why it takes so long. Where are all the other judges, you might ask? I know I ask it often in my civil litigation practice, because we have the same problem. We often have one judge for jury, one judge for non-jury. So we got two judges in a county for all the civil litigation in that county. So where are all the judges? They're in two places. Criminal, where you have constitutional rights that have to be abided by. You have speedy trial issues. You need judges to process those criminal cases, or you got to be letting people free. So the criminal division of these courts have tons of judges. Drug dependency court gets judges. Juvenile court for juvenile justice, the criminal side, gets judges. Both because of the constitutional issues and because you're really trying to provide a remedy for a juvenile that is not just throw them in, juvenile jail.
Wouldn't you think the juvenile criminal and the family court almost go hand in hand?
In some ways they do, but since family is not criminal and juvenile justice is criminal, they get separated. So those divisions, along with a couple others, get the judges, and family and general civil don't get much coverage. And it's actually the same is true if you go to the southern counties. You go to Miami-Dade, okay, you're not going to have one or two family judges. You may have 20 in the courthouse. But that's because it has such a larger population that they have 20 family judges, but whereas we may have 15 other judges, they have 150. So the ratio is still roughly the same. It just seems like they have so many more judges.
No, they've also got 3 million people.
That's right. So you got to understand that this takes time. I've asked a couple of attorneys, well, what about an emergency petition? And I haven't had to do one of those myself, but I'm told unless that petition involves the child's actual physical safety being at risk or something health-wise, it's not an emergency. So you get into the normal queue, and that could be 6 months, 12 months. Now, if you have a real emergency, the courts are very responsive. You have a serious situation. For whatever reason, you believe that your former spouse is about to abduct your child out of state. You'll be able to get into court tomorrow. Or maybe even today. Because you need immediate action. Or your former spouse is about to take the child to Colombia, where they're from. Oh, no. You need to stop that. Because you don't know if that child's ever coming back. You'll get into court very, very quickly.
What if the spouse has just gotten a great job in Seattle or Salt Lake?
Wonderful
or someplace
question.
Like that?
This happens a lot. I would say to that spouse, do not take that job and take the kid without first filing a petition for modification. Trying to get a temporary injunction allowing you to go, and at worst, if you can't get that in time, I would say best thing for you to do to be on the good side of the court is leave the kid with the other spouse or with your parents half time while you're resolving this so that you take your job. The problem is if you take the kid without court permission, in violation of the standard order of dissolution, which restrains you from taking the child out of state or out of the country, and you come back to the court 9 months later, when the court's ready to hear it, and you're asked, well, what did you do with regard to the child 9 months ago? Oh, I took him with me. You're not going to be treated very well because you just basically use self-help. You can't do that, especially when the other spouse has a right to access to the child. And now the time-sharing arrangement's impossible because you've just gone 3,000 miles. But let's say you follow the rules. Are you able to take that job? Absolutely. What will happen is there'll be a time-sharing modification. So let's say instead of week on, week off, maybe you get primary physical custody of the child because the child's going with you 3,000 miles away. What does that do to the other spouse who was seeing the child, let's say, week on, week off, half the time? Well, that spouse is going to get a lot of benefits to try to make it even. Instead of sharing winter and spring breaks, I can guarantee you that child is coming back here for both breaks full time. And the one in Seattle is paying for it. The airfare.
Oh, okay, yeah.
It's not going to come out of the one who stayed here.
Okay.
I can guarantee you that, let's say, alternate birthdays, that one in Seattle's paying for another trip back here for the child. so that you have opportunities to spend birthdays with your kid. Whether it's Hanukkah or Christmas or Kwanzaa or whatever you may celebrate, or Rosh Hashanah, Yom Kippur, or Easter. The one is in Seattle is not getting them all. It's probably still going to alternate. And the one in Seattle is probably paying the transportation costs to send the child back to Florida. So yes, you can move. The judge is not going to stop you from moving if it is to better your career, and particularly if it's more money and that helps the child. But you are going to have to accept the fact that you're going to have some financial burdens that you might not otherwise have had, so that the spouse that is left here is not further financially burdened in terms of getting to see their kid. So there are serious modifications there. It's easily done. It happens relatively frequently, but my suggestion to everybody is follow the rules. Don't just snatch your child and take them with you, because then you may find the other one's getting primary physical custody, and you're paying to have the kid come to you when you want the kid. Don't peeve off a judge. Get an attorney that tries to at least follow the rules as much as possible, so that you have the white hat. You don't want the black hat. Also, once you file these petitions for modification, unless there are emergencies, before you ever have a hearing, a trial, you're going to be ordered to go to mediation. If it works, wonderful. If it doesn't, you're getting ready to rumble in court. So, since we only have 5 minutes, this is a good time. Bottom line. It's important to determine your child's best interests and preferences. That's what counts, not yours. And let's be blunt. If you really care about your kid, what matters is your kid, not the passive-aggressive antics of your former spouse. In preparing for the modification, try everything you can before you do it. It's in your child's best interests, it's in your best interests, and it's more cost-effective. If you do have to pursue a petition for modification, be prepared. It's going to cost you. I mean, it could cost you $10,000 or more. You're going to go through discovery, have to file all sorts of documents, have a trial. Hate to say it, but lawyers are not inexpensive. And the bottom line then is it's not pretty, but sometimes it is necessary. There is only so much one spouse or one former spouse can bend. There's only so much one former spouse can lose face before having to declare war. There's only so much one parent can practically be guided by the best interests of the child before their own ego gets involved. And that's not a bad thing, it's a human thing. However, only you know your former spouse. And only you know, hopefully, what levers to push in a positive sense to try to encourage a result which is consistent with the best interests of the child. So, in a nutshell, that's it, without questions, which can be done not today, because we only have 2 minutes, but can be done at any time and any Friday. Family law is emotionally exhausting. Very often, lawyers get calls from one of their clients, and it's as if the client is yelling, "Fire." And sometimes there is a fire. Not literally, but figuratively. And sometimes that client just believes there's a fire because of how emotionally sensitive it is. These are very, very tough situations. They're tough for both spouses. Sometimes one's wrong and one's right. Sometimes both of you have merit in your position. The goal is to try to figure it out as best you can with whatever aids you can use before getting lawyers involved, because it's going to cost you a lot and take a long time. But if it does become necessary, then it's time to do the tough thing in the best interest of your child. Anyway, this has been Ask a Lawyer. Call Cheryl at my office, 781-8003. She's just dying to talk to you. And I'll be back next Friday on my birthday for Ask a Lawyer. Until then, have a great time. Have a good weekend. Have a good week. Bye-bye.
You'll be 21 next week? Is that
I'll be 21. That's right.
There you go. All right. Ask a Lawyer right here on WPSL, Port St. Lucie, WPSL.com. Webcaster to the world on Alexa and Google Home.